Thank you. It's never a good thing to follow Tom. It's hard to make anything interesting compared to Tom's presentation on patents. But I'm here to talk about copyrights. Hopefully, where are my slides? Magic people in the back.
They are.
Let me also say, while we're waiting for slides, it's great to be back live. This is the first time we're back live since 2020. I know it's an adjustment, so I'm going to try to make this as Zoom friendly as possible. And for those of you watching on Zoom, I'm not wearing suit pants that match this. I'm wearing workout pants, so it's very, very Zoom friendly.
But he is wearing pants.
Yes, I always wore pants during the Zoom era. It turned out to be a really good strategy. So that's my word of advice. Okay, now we've got the slides. Great. Yes, thank you. Great. So I'm going to talk about copyright law and trends, and there is a lot to discuss. So I'm going to move quickly. I'm going to talk about the U.S. Supreme Court decision in Warhol, which is not come out yet. So there's not too much to say except to set it up and talk about how it can impact the art world, entertainment and tech industries, and of course, social justice. Copyright fair use. I'll talk a little bit about AI art, NFT reuse, and related issues. Links in social media. And if I have time, I'll say a word or two on damages. There also are some issues that I'd be remiss to overlook, but I'm not going to get into in too much detail, so I put them here on the first slide. One of them is that we've now had a year experience with the CASE Act. My advice to clients always is to ignore the advice that it is a voluntary proceeding, because if you are served and do not respond, it becomes binding. So you have to opt out. It's voluntarily only in the sense that you have a right to opt out. I think there's further discussion later today on it. It's a very, very interesting procedure. And the Supreme Court issued an important decision in the last year in the Unicolors case v. H&M. And that deals with the safe harbor created by Section 411B1 for mistakes in copyright registrations. Now, you patent lawyers are going to be surprised that a copyright registration and what you put in it isn't as important as you think. And there can be mistakes, and there can be lots of mistakes. Section 411 says that a registration certificate is deemed sufficient even if it contains inaccurate information, unless, number one, the inaccurate information was included on the application with knowledge that it was inaccurate, and number two, that the inaccuracy, if known, would have caused the registrar of copyrights to refuse registration. The Supreme Court in the Unicolors case made that provision even more copyright owner friendly by holding that, first of all, the safe harbor applies to both mistakes of law and mistakes of fact, and that the knowledge provision is based on subjective knowledge. So you can be unreasonable in not having knowledge from an objective standpoint and still benefit from the safe harbor. Now, there were arguments made that that is not a good standard, because of course any copyright registrant would have the incentive to say, gosh, I had no idea that this certificate is completely wrong. But the Supreme Court said that we litigators know how to prove that people are lying in litigation, so it's not a concern, apparently. In any case, that's a very, very pro-registrant decision, and not surprisingly, on remand, also in 2022, the court found that the copyright registrant, Unicolors, came within the safe harbor. So very important decision. Let me move on to fair use and the other issues. I should also mention I've included in the materials excerpts from my treatise, which should be shown here on the slides, but seem to have been stripped out by the security procedures here at Finnegan or at Howard Law School. So just imagine, if you will, images of my treatise. Here they are in black and white. Anyway, but there are indeed excerpts from the treatise. So any of you who are having trouble sleeping in these difficult times, print them out, and you'll be able to sleep like a baby. So the first issue I'm going to talk about is AI, art, and copyrightability. And artificial intelligence is a very hot issue. It's not generated as much case law, but it has certainly occupied almost all companies that operate in the copyright sphere. And I deal with the copyright and related issues involving data portability. There also are some very important privacy issues, which I'll say a quick word about later in this presentation. But one of the social justice questions involves how AI is going to impact independent artists, because AI can create art. AI can do a lot of things. And in fact, there's been a lot of attention in the past month or so to Chat GPT, which is a great tool. Apparently, it can write better privacy policies than most of us lawyers can. So I went to Chat GPT to ask who I was. And it was pretty close. It was not entirely accurate. It says that I'm a litigator. I'm head of the IP practice group at Greenberg Traurig, but it also says that I head the firm's blockchain and digital assets group. The lawyers who actually head that group might not be so happy to know that. Who knows? And then further, it turns out that during the pandemic, I wrote another book that I didn't even know about. Apparently, I wrote a book on blockchain and cryptocurrency regulation. Who knew? But you know, the algorithms can't be wrong. So, hey. But an area that's gotten a lot of attention in copyright involves the intersection of artificial intelligence and art. So I took some pictures of myself and wanted to see if AI could improve them. And don't tell me these photos are missing, because here we go. Here's some. Okay, good. Phew. All right, here you go. So you can see that artificial intelligence can generate all kinds of pictures. These look like works of art. Some of them look better than me. Some of them look worse than me. This one I thought was pretty good. So it's actually now my Facebook profile photo, because I'm never going to look that good. So there you go. Now this one, on the other hand, is kind of creepy. I have 3 sets of teeth, upper, lower, and middle. And this one's really creepy. A short sleeved suit. Come on. So, you know, AI is not yet at the point of putting out of business real artists, but it does create a lot of interesting questions. One of the first ones is, can artificial intelligence obtain a copyright registration and enforce the copyright? And we know, based on the monkey selfie case from my home circuit, the Ninth Circuit in California, that artificial intelligence agents would not be able to enforce copyrights because this comes back from the monkey selfie case. You may remember that there was a precocious monkey who had been posed for a photo by a photographer, and because this was a precocious monkey, he reached over and pressed the button. And because this is America, someone filed suit on behalf of the monkey. But it turns out monkeys don't have standing in federal courts. The Ninth Circuit held that animals other than humans lack statutory standing to sue under the Copyright Act. So we do not need to worry about machines creating art and then suing us for infringement. Most of the copyright issues come actually in the opposite way, where machines create art and then live human beings would sue, alleging that the machine works are infringing. And so then the question is, are these works of art going to be infringing, or are they a fair use? And I don't have case law on that, but the way I think you need to look at it is really in terms of 2 questions, which is, 1, how is the algorithm written? And number 2, what inputs are you using to train the algorithm? So if the algorithm is written to take photos to make them look like Andy Warhol paintings, then the estate of Warhol may have a claim for infringement. Now, it's not crystal clear they have a claim for infringement, because painting in the style of an artist may not be protected. It's works that are protected under the Copyright Act, not necessarily style. And we know that from a series of cases from about 3 decades ago dealing with the look and feel of software. But at least, you know, if you train an algorithm to emulate a particular artist's work, then that may be a problem. And then the second thing that I think you need to look at is what are the inputs? And again, if you train your algorithm with millions or tens of millions of images, everything on the internet, and it just happens that this particular work looks like the work of a particular artist, there's probably an argument for independent creation. On the other hand, if you train your algorithm and 30% of the paintings you use are Andy Warhol paintings, then the estate of Warhol would probably have a claim that what you've done is you've trained your algorithm to copy Warhol paintings. So I think those are the two things that you would look at. Again, we don't have case law, and generally when I write things in my treatise, courts tend to disregard what I say. In fact, the treatise has been cited more frequently for the opposite proposition than what I actually say, which means there are law clerks who need a cite for something, but they don't actually read closely. But you know, there's no such thing as bad publicity, so I'm not going to argue with it. But I think that's the way you would look at these things. Now, the policy question, will artificial intelligence put independent artists out of business? I don't know. I mean, in the art world, paying homage to other artists is something that has happened, you know, from time immemorial. There's a great work of art, and then another artist repaints that painting. So if algorithms create work that pays homage to other artists, it might bring a certain fame to the original artist. I don't know. Obviously, I can't answer those questions. I just pose them. That's why we're here in a law school, to ask questions and let other people answer them. But that is the policy issue. Will artificial intelligence put artists out of business? Or on the other hand, will it allow you know, the individuals that Latif was talking about in North Dakota and West Virginia to now create their own art? In other words, will these tools allow people to become artists and have more of a democratic impact? So interesting questions. I do think, as I said before, that AI is only as good as the test data used to train it. And so one of the issues that comes up frequently is data portability. Can you get data? And there are important copyright issues, but there also are other issues as well. So I've put these all on a single screen, which may be difficult for some of you to read. For those of you coming out of the pandemic, this is your 2023 eye exam. Luckily, the slides are or should be available or will be available, or contact me during the break, or for those of you on Zoom, by email or through social media or other modern means of communication, and I'll send them to you. But what we find in the data portability area is that copyrights provides the strongest remedy, but in many instances is very hard for a copyright owner to enforce when a third party takes your data or information. And then we find that there are other non-copyright remedies, such as breach of contract, that may be easier to establish, but with a more uncertain remedy. So let me drill into that a little bit. Let me also just mention a couple of very, very important concepts that I'm not going to drill into. One of them is privacy law. So privacy law in Europe and in my home state of California create a right to opt out, or a right to be forgotten. Well, that has implications for artificial intelligence, because as I said, an algorithm is only as good as the data used to train the algorithm. So if you remove from databases a bunch of information that not in any kind of statistically significant way, what you're doing is you're going to be training your algorithms based on incomplete information. So that raises a big policy concern. The other thing that I'm not going to talk about, but is extremely important, is bias, which is, again, an algorithm is only as good as the data used to train it. And so, for example, in a well-publicized study a number of years ago, they found at MIT that algorithms trained to predict creditworthiness skewed very heavily in finding that white men were much better credit candidates than almost anyone else. And the reason for that is they plugged in 50 years of data back in the days when you had greenlining and redlining, and you had official legal policies of discrimination against people who were not white. And so that raises big policy issues. Most companies that work in the artificial intelligence area have ethics committees to try to figure out what is ethical in this space. But the issues of ethics and bias are very difficult and very important. and need to be attended to. So let me turn back to copyright law. So as I said, copyright provides the strongest remedies for copyright owners in preventing third parties from using their data or information to train test sets. So we know under the Copyright Act, you can get statutory damages, attorney's fees, even actual damages, very strong remedy. A copyright owner can recover the wrongful profits of the infringer and, to the extent not duplicative, their lost revenue. So you can get more than what the infringer ever made. So very strong hammer, and the statutory damage hammer can be very strong, particularly when you've got an individual or companies taking an entire data set to try to train their algorithms. But it may be difficult to establish copyright infringement because we know facts are unprotectable. We know that from the Feist decision. Feist involved white page phone books. For those of you in the audience under a certain age, which is most of you, a white page phone book was a book that the phone company used to publish listing everybody who had a phone and their name and address. Talk about privacy violations. And they used to distribute these things. And they put errors in there intentionally to show who was copying them. And the US Supreme Court, more than 3 decades ago, said that rejecting the sweat of the brow doctrine said that just because you spend a lot of time and money creating something doesn't mean it's entitled to copyright protection. There has to be minimal creativity, and creating a database or well, a phone book, but in today's world, a database of all the data in a particular universe does not mean that it's entitled to copyright protection. But if there's creativity in the selection, arrangement, or organization of the data, then that may be entitled to copyright protection. So if you create a database of the best lawyers in Washington, D.C., maybe there's some creativity in that in terms of who you include and who you exclude. But it's entitled to what's called a thin level of copyright protection. So if the whole database is taken, then maybe you've got an infringement claim. But if only pieces of it are taken, you don't have an infringement claim because the facts themselves are unprotectable. Well, that gets even more complicated when you're dealing with data used to train algorithms, because is the data copied? Well, if you take the whole database and copy it, and let's say you keep it for a year because you want to keep training your algorithm, well, that prima facie creates a copy. On the other hand, if you extract data from the database without making a complete copy, then it's not going to be a prima facie case of copyright infringement. And what about if you just copy it and delete the data? Then it's intermediate copying, and maybe that's a fair use, maybe it's not. There are a lot of issues here, and so those on the transactional side, for example, AI issues come up a lot in mergers and acquisitions, and sometimes I get brought in as the litigator to opine on these issues, and it just drives the transactional lawyers crazy because there's so many layers of analysis that it's very hard to predict at the outset, except in broad terms. And really the ultimate answer is have a big holdback for your M&A acquisition because there may be litigation. So there are a lot of issues there. As you can see, the upshot is there's a strong hammer of a remedy, but if you're dealing with factual data, it may be very hard to establish copyright infringement. That's also true under the anti-circumvention provisions of the DMCA. If you access a database by circumventing copy protection mechanisms, you may have a claim under the DMCA, and there's statutory damages. But there's a split in the circuits over whether you have a DMCA claim if what's extracted is not itself copyrightable. So again, you have the problem of extracting unprotectable data. Again, strong hammer of statutory damages, real question whether you can establish infringement. So in these areas, it's actually adjacent non-copyright remedies that often are relied upon. For example, from 2022, the Meta Platforms case enforcing terms of use. Automated access violates terms of use. There may be other claims, trespass, Computer Fraud and Abuse Act. I've got a 140-page chapter on that. So again, if you have trouble sleeping, print it out. It'd probably take 10, 15 minutes to print, and just read it late at night. But I think, you know, the point is there are a lot of issues to look at here, and it's not just an issue of copyright. It also impacts these other things. I think what you need to look at from a big picture, you need to look at what is being copied. Is it copyrightable? Is it facts? Or is it something copyrightable, like photos or art? And then you need to look at how it is being accessed. Is it just out there freely on the internet, or are you agreeing to terms of use that say you can use this for one purpose but not another, or circumventing access or copy protection mechanisms? You need to look at what's being copied and how it's being accessed, and then what you're doing with it. Are you making an intermediate copy? Are you just quickly accessing data? Or are you holding on to it for a year or two to keep training your algorithms over and over and over so that they become better? That certainly impacts fair use. So with that, let's turn to what the Supreme Court is going to look at, which is the Warhol case. Copyright fair use, as you know, is a multi-part balancing test. That's why it is one of the areas of copyright law most frequently reversed on appeal. Because when you've got balancing tests, you could line up 10 judges and they're not necessarily all going to agree. You could line up 10 copyright lawyers and we won't all agree. So it is, this is an interesting case. We had just in 2021, the Google v. Oracle decision, which was an important decision, 9-0, expanding this concept of transformativeness, because in the Campbell v. Akoff-Rose case, which involved hip hop sampling, the US Supreme Court adopted this concept of transformativeness from Second Circuit Judge Laval, holding that if something is transformative, if you take something, copy it, but use it for a completely different purpose that advances the useful arts and sciences, then that's more likely to be fair use, impacting the first factor. Well, in Google v. Oracle, Justice Breyer said that transformativeness is so important that it can impact all 4 factors. So that's even more significant. But he retired, and we have a new, we have Judge Coney Bryant in his place. He's not going to write the opinion. And it will be interesting to see the Warhol decision that involves this photo and this painting. Photo of Prince, which was used by Andy Warhol for this famous painting. And again, as I said before, for generations, artists have taken other people's works and paid homage to them by repainting them. And in the art world, a lot of people look at this and say, if Andy Warhol is not transformative, who is? I mean, it really raises an important question. The Second Circuit, I think, got it wrong. Although remember, I've told you my view is rarely followed by courts, except when I actually litigate. Then the courts sometimes pay better attention to me. As a litigator, you should never tell people that no one listens to what you have to say. So I had to make that correction. So I think the Second Circuit got it wrong, in part by looking at earlier cases, which is what courts often do, because we litigators have to look at what the precedent is. And the precedents there, you had 2 collage cases, Blanche v. Coons, Cario v. Prince, where you have, in Blanche v. Coons, you have a piece of an ad involving legs that were taken for a collage involving many legs, and the court said that was a fair use. And Cario v. Prince, where you have a photo of an Aboriginal, and he's given a guitar and some paint, and the court said that was also transformative and a fair use. And then you have Rogers v. Coons, where Jeff Koons, the well-known contemporary artist, asked a foundry in Italy to take a look at a postcard he sent them and copy it as exactly as possible. Now, as a copyright litigator, this is not something I really want someone to say at a deposition, but it was in writing, so what can you do? But that was also pre-transformativeness. The Koons case doesn't even talk about transformation. It was decided based on what was most relevant at that time, impact on the market for the genuine product. So I think the Second Circuit really got it wrong by going back and either looking at collage cases, which are a little bit different, or pre-transformativeness cases. But in fact, the Supreme Court may decide on entirely different grounds, because of course they're not bound by precedent. And Chief Justice Roberts had a very telling question that I think might influence how it's decided, which is, he said, well, you know, if this work is transformative, how do you deal with screenplays? Because every screenplay based on a book is a little different. Change the plot, add some characters, use a different focus. You know, wouldn't this impact things? Now, I think there's an answer, which is in the art world, it's very different. And you know, and art is different than screenplays. That isn't what the art, you know, what was said. Running low on time, so let's move to NFTs. NFTs, non-fungible tokens. For a while, they were all the rage. Former President Trump issued some non-fungible tokens. This is fan art, and the portly former president is made to look svelte and like an authoritarian superhero. These generate a lot of money for him, but it turned out 98% of the value was lost. Maybe not the best investment. Could you imagine President Trump having a bad business deal? Hard to imagine, but there you have it. So NFTs, I think the big issue, which we lawyers know, whenever there's a new technology, entrepreneurs out there in the world say, oh, it's the Wild West, we can do anything. But we copyright lawyers know, actually not really. An NFT may be reproduced. It may be distributed. It may be publicly displayed. All of those implicate copyright law. The other big issue in the copyright world is that an NFT does not necessarily give you the rights to the underlying intellectual property. So you may buy an NFT of a work of art or something else. That doesn't mean you have further rights to exploit the underlying work. There was a case on that, Miramax v. Tarantino. The case settled, but the issue there really is what are the rights. And a lot of these cases are being decided by contract, by license, and that's an important thing. So I'm out of time. So let me tell you, I would have, had I had more time, talked about links. And there are slides here on links. The two cases I would tell you to look at, which I would have talked about, but more interesting to read them directly than to hear what I had to say. McGurkin v. Newsweek, a 2022 decision denying summary judgment on both sides, really lays out the issue. The Ninth Circuit says the server test, Southern District of New York does not apply it. This case is going to go on appeal to the Ninth Circuit, but it really, in a good way, lays out all the issues. See all my marks? I even got a red flag. Good case to read. And then finally, Hunley v. Instagram, 2022, motion to dismiss. And this one, actually, I'm sorry, this is the one to the Ninth Circuit. This is the problem with rushing without my slides. My slides tell me what I need to know. This is the one going to the Ninth Circuit. Hunley v. Instagram, challenging the whole issue of the server test. But McGurkin v. Newsweek is a good one to lay out all the issues. So read those two cases and then contact me online. I can ask you Socratic questions. Always an honor to be here. Thank you so much for having me here. And Esther, let me turn it back to you.